All right, let's dive right into this fascinating explainer where we're going to unravel the incredibly complex, almost hidden legal tug of war happening inside property mortgages. When most of us think of a mortgage, we just picture a totally straightforward loan to buy a house, right? But beneath the surface, property law actually treats a mortgage as this highly strategic, high stakes game of chess between the person borrowing the money and the entity lending it. And today, we're going to decode the exact rules of that game. It really brings up a provocative question, doesn't it? Who actually holds the power here? I mean, does the lender have the absolute upper hand just because they control the capital? Or does the borrower hold the fort because, at the end of the day, they own the physical property? Well, as we dig into these legal sources, you'll see the answer actually shifts back and forth, depending on the specific moves each party makes. So, to figure that out, we're going to break this explainer down into a 5-part strategic playbook: the mortgage power dynamic, the mortgager's redemption rights, the legal fiction date, the trap of taking possession, and finally, foreclosure and its exceptions. Okay, let's kick things off with Section 1, the mortgage power dynamic. Let's look at the lender's offensive toolkit. Now, this toolkit drastically changes depending on the specific type of mortgage they hold. There is a massive, fundamental difference in power here. A legal mortgagee, someone who takes the time and expense to properly execute and perfect a legal mortgage, is rewarded with incredibly powerful, automatic statutory rights. Basically, if the borrower defaults, a legal mortgagee can often just sell the property without ever asking a judge for permission. But on the flip side, an equitable mortgagee, say a lender who just held on to the borrower's title deeds as security to save some time up front, well, they usually have to go beg the court for an order before they can make any move to sell. So it's cheaper initially, but it totally costs them their automatic offensive power. Moving right along to Section 2, the mortgager's redemption rights. Now let's flip the board around and look at the defensive shield of the borrower, or, the mortgager in legal jargon. Because thankfully, the law doesn't just leave borrowers defenseless against the big banks. The absolute crucial concept here is the equity of redemption. Honestly, this is basically the mother of all rights for the borrower. It's a proprietary interest that begins the exact millisecond the mortgage is created. Think of it like an invisible shield, ensuring the lender is only ever holding the property as security and literally stopping them from just running away with the asset at the very first sign of trouble. And this brings us to one of the most famous, heavily quoted maxims in property law, stemming all the way back to the historic case of Vernon v. Bethel. Once a mortgage is always a mortgage. What this means in plain English is that any sneaky, hidden clause a lender tries to slip into the contract to block the borrower from ever getting their property back, what the law calls a clog on the equity of redemption, is completely 100% void. No way around it. The law absolutely insists that if you borrowed money against a property, you must have a fair, unhindered chance to get it back once you pay off the debt. So how does the borrower actually use this right in practice? Well, there's a strict timeline. First up, they have the legal right to redeem, which means they can just pay off the loan on or before the agreed-upon deadline. Simple enough. But what if they miss that deadline? Under the strict ancient common law, they would just lose the house forever. Boom, gone. But here's where equity steps in to the rescue. The equitable right to redeem window flies open the exact moment that legal deadline passes. This allows the borrower to still save their property by paying off the debt, as long as the lender hasn't already validly sold the property or gotten a final court order. Which naturally leads us to Section 3, the legal fiction date. Now, this is a very clever, kind of sneaky strategic play used by lenders to counter those borrower rights we just talked about. See, lenders quickly realized that if they gave a borrower, say, a 24-month repayment plan, their hands were completely tied if the borrower defaulted in month 2. They legally couldn't trigger their power of sale until that final 24-month deadline actually passed. So they invented something called the legal fiction. They'll purposefully draft the mortgage deed to state the loan is legally due in just 6 months, even though the actual agreed-upon installment plan spans 24 months or even 20 years. Now, what's really fascinating here, and absolutely crucial to understand, is that this shorter fictional date is not a punishment for the borrower. As we've seen in cases like 20th Century Banking Corporation v. Wilkinson, the legal fiction date absolutely does not force the borrower to pay the whole massive loan back in 6 months. It just legally moves the finish line closer. That way, if the borrower suddenly stops paying their normal monthly installments in, say, month 7, the legal due date has technically already passed. Boom. The lender is instantly armed with the power of sale. It's just a brilliantly drafted safety switch. All right, let's jump to Section 4, the trap of taking possession. Now, having the power to act is one thing, but choosing exactly how to act is quite another. And this leads us to a massive, potentially ruinous trap for lenders. The law explicitly states that a legal mortgagee can literally march right in and take physical possession of the property the moment the ink is dry on the contract, even before any default has happened. It's an automatic, no-fault remedy. Sounds like the ultimate flex of lender power, right? But plot twist, they almost never, ever should do this. Why? Because taking physical possession traps the lender in an absolute nightmare of strict liabilities. According to established case law, like White v. City of London Brewery, if a bank takes possession of a rental property, they must account to the borrower not just for the rent they actually managed to collect, but for the rent they ought to have collected if they had managed it perfectly. Plus, they have to pay for all the maintenance and repairs out of pocket and might even owe the borrower occupation rent. Suddenly, by trying to flex their power, the bank has accidentally become a full-time, highly liable property manager, not a position they want to be in. So, what's the ultimate strategic masterstroke instead? Well, when a default occurs, a smart, well-advised lender actively avoids taking physical possession like the plague. Instead, they pivot and exercise a totally different statutory power. They appoint an independent receiver. Honestly, this receiver tactic is an absolute game changer. A receiver is a totally disinterested third party, appointed to step in, manage the property, collect the rent, and then use that cash to pay down the mortgage debt. But here is the absolute magic trick of the whole shebang. Legally speaking, the receiver acts as the borrower's agent, not the lender's. This legally insulates the lender from all those terrifying liabilities of possession we just talked about, like accounting for profits they ought to have made, while still capturing all the property's income to pay off the loan. It is basically a perfect checkmate move. Finally, let's wrap up with Section 5, foreclosure and its exceptions. Now we need to deal with the absolute, ultimate, nuclear weapon in a lender's arsenal, foreclosure. While a standard power of sale just sells the property to some third-party buyer, foreclosure actually transfers the absolute ownership of the property directly to the lender. It's an incredibly strict process that requires a formal court application. It kicks off with a provisional order nisi, which gives the borrower one final, desperate 6-month window to scrape the money together. If they fail, the court grants an order absolute. And at that exact devastating moment, the borrower's sacred equity of redemption is totally and permanently extinguished. But even the ultimate weapon has exceptions, because remember, equity is always watching. The court can magically reopen a foreclosure absolutes under a few very specific right of foreclosure exceptions. For instance, if the property is wildly undervalued compared to the actual debt, or, here's a fascinating one, if a lender gets an order absolute, sells the house, realizes they didn't quite make enough to cover the original loan, and then turns around and tries to sue the borrower personally for the remaining balance. The law steps in and says, wait a minute, if you're suing for the debt, you're admitting the mortgage must still be alive. And just like that, the borrower can apply to reopen their right to redeem the property. So what you should really take away from this explainer today is that property law isn't just a list of dry, boring rules. It is a highly strategic, breathing dance of offensive and defensive maneuvers. From the unbreakable shield of redemption to the clever legal fictions and the hidden trap of taking possession, every single move has a countermove, leaving us all to wonder, does the law actually perfectly balance the scales between the borrower and the bank? Or is there always a hidden trap just waiting to be sprung by the better player? Definitely something to think about the next time you're asked to sign a massive contract. Thanks for joining me on this deep dive.